Hi, welcome. I'm Cornell Clayton. I'm the director of the Foley Institute, and on behalf of the Institute, I want to welcome you out to our event tonight. Yesterday the House Intelligence Committee held formal impeachment hearings for only the fourth time in our nation's history. The hearings focus on whether President Trump abused his office and possibly broke laws by pressuring the Ukrainian government to investigate Joe Biden, who's a possible rival in the upcoming presidential election. While many of the facts in this case really aren't being disputed, there is fierce debate about whether what President Trump has done are impeachable offenses. And I think much like the last impeachment we had of President Clinton in 1998, views about this are sharply divided along partisan lines. So to help us understand the impeachment proceedings and to put them in some kind of political and historical context, we've invited two leading experts from the region here to come and talk to us tonight. We're going to hear first from my friend David Adler, who's on my immediate right here. He is the president of the Alturas Institute, which is a nonprofit organization advancing American democracy by promoting the Constitution, civic education, gender equality, and equal protection. David is a recipient of teaching and writing and civic awards. He has lectured nationally and internationally and published widely on the Constitution, presidential power, and the Bill of Rights. He is the author of 6 books, including most recently The War Power and the Age of Terrorism, published by Palgrave Macmillan, as well as more than 100 scholarly articles in leading journals of his field. David's scholarly writings have been quoted by the U.S. Supreme Court, the United States Attorney General, the White House Legal Counsel's Office, and by Republicans and Democrats in both houses of Congress, as well as by academics. He has consulted with members of Congress from both parties on a variety of constitutional issues, including impeachment, the war power, and the termination of treaties. And as a side note, many of you, or some of you may know David because he actually lived for a short time here on the Palouse a few years back when he was the head of the McClure Center over at the University of Idaho. So David's going to speak first, and following David, we will have Stuart Chinn, who's to my far right over here. Stuart is an associate dean and a Goodwin senior fellow, as well as an associate professor at the University of Oregon School of Law. His research interests are situated at the intersection of constitutional law, political science, and political history, and they focus on how institutional and ideological dynamics have historically influenced American constitutional law and governance. He is the author of Recalibrating Reform, The Limits of Political Change, published by Cambridge University Press, and numerous articles in law reviews and social science journals examining American constitutional history and the politics of legal development in our country. Prior to joining the faculty at the University of Oregon, Stuart was a visiting professor at the University of Texas School of Law. He received his BA and his PhD in political science, as well as his JD from Yale University. So following Stuart's comments, we'll then have a brief discussion and then open it up for Q&A from the audience. So join me now in welcoming both David and Stuart.
Thank you, Cornell. It's very nice to be here. I appreciate the invitation. It's good to be on your campus again, and it's always a great privilege to be here at the Foley Center. I admire Speaker Foley's work very, very much. It's a loss for the nation that he's no longer back in Washington able to bring a sense of compromise. We could use that these days. I remember during the Clinton impeachment that particular semester in 1999, I was actually teaching a seminar on the law of impeachment. No faculty member can actually schedule that with that in mind because, as Cornell and Stuart will tell you, we schedule our classes half a year out anyway. But that was a marvelous experience because my students were able to participate, in a sense, in the daily discussions, and we had some United States senators that did some interviews with us. So it was a terrific learning opportunity. And so to be here to join you today on the next impeachment, I want to encourage you to try to soak up as much of these impeachment hearings as you can. Let's hope this does not come in your lifetimes again, but the chances are that they will. But it's a great opportunity to enjoy a seminar on the law of impeachment. I'm going to take a few minutes today to talk a little bit about the origins of the impeachment clause, what drove the framers, what motivated them, to, in fact, include the impeachment clause in the Constitution, and then maybe take a few subtle positions on the current crisis, or two or three. So remember that the framers of our Constitution were steeped in legal history. As they framed the presidency, they saw very clearly the despotic English kings and the conniving ministers that helped to inform their own views about government and the Constitution and law and politics. And as they were inventing the American presidency, one of their greatest concerns was how to limit it in a satisfactory way so as not to impede the power that the president would need to conduct the many responsibilities and duties of the office, but particularly how to fence about executive power, because that generation obviously lived in dread fear of a powerful executive, and being the keen students of history they knew how tyrants and despots and kings had marched their people onto the battlefield without their consent, not even engaging in any thinking about what constituted the interests of the people. They were very, very familiar with the long history of the use of impeachment by Parliament, going all the way back to the 14th century, to the very first exercise of the impeachment power in 1386. And so at the time that they met in Philadelphia, they were in a sense witnessing a great impeachment battle in Parliament involving Hastings, and they would get reports about the nature of the argument. So there's no doubt that their own time helped to fashion their views on impeachment, but more than anything else, it was their deep interest and familiarity with English legal history that helped to motivate them to craft the impeachment clause. Why have an impeachment power? They wondered. Old Ben Franklin, then 80 years old, said to his delegates in Philadelphia, well, without impeachment, then there'll be no recourse but to assassination if you want to remove a president who's so obnoxious. Rightly, the framers chose impeachment over assassination. The question is, what would constitute an impeachable offense? And so as the debate began in Philadelphia in the summer of 1787, the question of what would constitute an impeachable offense was at the forefront of their minds. Very interestingly, the framers drew from the peaks and the valleys of English legal history. In England, for example, the king could not be impeached, obviously, but in fact the king's ministers could. So what kinds of actions were carried out by the king's ministers that would warrant impeachment? They would include, for example, in the case of Lord Buckingham, a failure to properly guard English interests on the high seas. Many of the impeachments involved sordid ministers who were trying to reap benefits from their own office. They would try to advantage themselves. Others included judges who in England could be impeached for rendering opinions that ran counter to what Parliament considered to be the nature of the English Constitution. So there were a variety of offenses that helped to inform our own framers' thinking about what might warrant impeachment. In our own convention then, as the debate ensued, George Mason introduced the idea that in fact a president should be impeached for maladministration. But James Madison, his fellow Virginian, quickly said, well, that's too vague. It would put the president in the position of serving at the pleasure of the United States Senate, thus undermining his independence. And we need the president to be independent, which of course was one primary reason why the framers did not adopt the parliamentary system, instead opting for a system of separation of powers and divided offices. So we don't want to undercut the independence of the president. Well, if not maladministration, what might it be? So George Mason and others said, well, clearly bribery and treason should be impeachable offenses, because indeed those were categories of impeachable offenses at English law. As in so many other areas, the framers were tutored by English law and adopted many of their practices I should say, except those which they rejected. So bribery and treason, those were terms that were pretty familiar to everybody, didn't require much in the way of definition. But what else? As George Mason said, well, there could be a lot of offenses that might be committed by the president or another civil officer, for example, that wouldn't fall into the category of bribery and treason. So at that point, Mason said, well, let's introduce high crimes and misdemeanors, other high crimes and misdemeanors, so as to capture other kinds of actions by the president. Well, what kinds of offenses would fall into that category, other high crimes and misdemeanors? Here the framers would offer us not an exhaustive list, but a laundry list, which would include, for example, usurpation of power, subversion of the Constitution. Also, it would include, interestingly, the failure, or excuse me, the willingness of a president to conceal intelligence or information from Congress when it came to foreign affairs. Keep that in the back of your mind. Usurpation of the war power was another offense that would warrant impeachment. And so as the discussion went on, the framers were essentially engaging in an effort, if not quite to altogether enumerate every single impeachable offense, at least to establish some broad categories. It was not the case that the framers considered that before a president could be impeached, that he would have to commit a crime, because the framers separated the realm of impeachment from the realm of jurisprudence. The prosecution of a crime belonged to the criminal justice system. Impeachable offenses were essentially great political offenses that might rock the foundation of the state, that might threaten or inflict a great injury on the public or the community. And so even though it has been suggested throughout American history by some partisans defending presidents who have at one time or another been the subject of impeachment hearings, and that's true whether we're talking about Andrew Johnson or Richard Nixon or Bill Clinton, or even in the case of Donald J. Trump, it's not been the case ever in American history that the commission of a crime had to occur before the president might in fact be subject to impeachment. As the framers moved throughout the summer of 1787, then, they became reasonably confident that in fact they had found yet another way to fence about executive power and to protect the nation from an obnoxious president, so obnoxious that you couldn't wait 4 years or 3 years till the next election, because in fact while the aim of the impeachment power was not so much to punish the president as it was to protect the community from the president. Protect the community from the president because you wouldn't know what he might do, and someday what she might do. And so the reality is that the framers were essentially making an exception to separation of power. They were building in yet another check and balance. What are a couple of other highlights here to help us better understand the scope of the impeachment power? The text of Article 2, Section 4, as you may recall, provides that the president or the vice president or other civil officers of the United States may be impeached for the commission of treason, bribery, and other high crimes and misdemeanors, essentially offenses against the United States government. The one textual limitation is that on the president's power to grant pardons is that he may not grant a pardon in the case of impeachments. Let me reiterate that. When you look at Article 2 and the enumeration of presidential power, the president's authority to grant pardons is perhaps the most imperial of his powers, but he may not grant a pardon in the case of impeachment. Why is that? Here the framers took their cue from English legal history. In 1686, when Charles II wanted to fight a war in Europe. He could not get funding from Parliament, so he told his loyal aide, the Treasury Secretary, Lord Danby, go around to other countries, raise some money, very quietly, secretively, bring back the war chest so I can engage in war. When Parliament learned about that, it erupted with great anger, and it decided it was going to impeach Lord Danby, even though he was carrying out King Charles II's order. And as the impeachment trial began, the king came down and said, "You're not going to be able to impeach Lord Danby. I'm going to pardon him." And the Parliament retorted, "No, you won't. If you pardon him, you're going to have another civil war." In a century riddled with civil wars, the last thing any king wanted was yet another civil war. So that example provided the basis for the textual limitation in Article 2. What's the import of that? And I'll wrap up here quickly. What's the import of the textual limitation on the power of the president to pardon people who are subjects of impeachment? What it says to us is this: a president may not interfere with impeachment proceedings because an impeachment, which the framers called the grand inquest of the nation, the ultimate way to bring an errant president to heel, summons all the powers possessed by Congress, and it requires the president to turn over documents, to bring testimony sought before Congress. And what the story about the pardon power tells us is that the president may not in any way interfere with an impeachment proceeding, which means that when, in my view, when President Trump is resorting to executive privilege or some vague claim of absolute immunity to prevent his aides, current and past, from coming to Congress to honor the subpoenas, that he has no basis for the assertion of that power, because if Congress is denied the opportunity to conduct an impeachment proceeding without the information that it requires to get at the facts, to display the truth, then in the framers' own mind, the ultimate way to bring a president to heel has just been undercut. And the impeachment power, the framers believe, was critical to the maintenance of our constitutional republic. That's why today, when President Trump is denying his aides from complying with subpoenas, that we are looking at a very dangerous situation here in America. If Congress is deprived of the opportunity to bring a president to heel, then we wonder, what are the limits on a president? And indeed, what should happen if the president should survive this proceeding? Will the lesson be there are no limits on the president? Thank you.
Well, so first, thank you, Cornell and Richard, for the invitation, for hosting for this visit here. I'm really happy to be here to be talking about this subject. I want to start off with what I think is a less controversial claim to build to maybe a more contentious thing, but I'll start the same part where Richard was focusing, which is the text, the impeachment clause. Again, it says that the president, the vice president, all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. And so what I want to focus on a little bit is that language at the end, which seems to be a lot of the focus in discussing impeachment, which is how to think about giving substance to that phrase, high crimes and misdemeanors. I think it's pretty well established by our practice, by past scholars, by past politicians as well, that when we think about what rises to the level of an impeachable offense, it's not mere partisan disagreement, right? Partisan disagreement is pervasive through our history. It's a normal part of how things function, and it's how important policy issues get resolved and discussed. And one might feel very strongly in the idea of economic equality, but just because the president might want to give tax cuts to very rich people, that would not strike me, and I think most, as a grounds for impeachment. I would make the argument instead that more appropriately, in giving content to high crimes and misdemeanors and what rises to an impeachable offense for that text, it really encompasses at least two different kinds of situations. So one situation I would say are those moments in our history where we might say it's not normal political disagreement, but it's constitutional political disagreement. So what I have in mind is the impeachment around Andrew Johnson. So the context there is there's just been a civil war. There's real disagreement between President Johnson and a Republican Congress about the nature of how the South is going to be governed after the Civil War is over, and what is the nature of equality for recently freed African Americans in that region, and what would that look like? And you had two very different visions that come forward between both President and Congress, and that clash ultimately resulted in an impeachment. And in that context, that would strike me as actually totally appropriate. The stakes were high. The scope of disagreement was particularly severe, and at stake was nothing less than thinking through what equality would mean in the post-Civil War era. So that seems like a kind of conflict that would be something that would fall within that phrase, high crimes and misdemeanors, political disagreement that would fall within that category. But a second category, which I think is probably more relevant in thinking about this current controversy around President Trump, is when there has been a transgression of what we might consider fundamental constitutional norms, right? And so just to give context to what I mean by what these norms are, I think the point is maybe intuitive to think about, but imagine you were part of any sort of organization, whether that be academic department, student club, or whatever, and you're thinking about how will the business of this group be conducted? And so typically we might think that what would emerge would be some set of rules to govern how behavior would occur. And I think that's probably how oftentimes many of us think about our constitutional structure. We think about the Constitution as demarcating set textual limits on powers or grants of authority and rights. And so we think about our structure as this sort of system of rules. But I would make the argument that as important or equally important to those formal rules is a background system of norms that makes the whole thing function, right? And so to go back to our example of a student club or an academic department, yeah, what would probably be the thing that you would write in a policy would be those situations or those conflicts that you thought would be the ones most likely to arise. But consider all the conflicts that would never come up just by virtue of the fact that there are these unspoken background norms and rules that exist that are going to govern conflict before they ever rise to the level of demanding a need for a rule. And I would make the argument that much of what makes our constitutional government run is precisely the existence of such norms. So taking that basic point to the present context, I mean, I would argue again that if you have a situation where you have a president that is a serial transgressor of what we might think of as fundamental constitutional norms, we would then be in the territory of what we would consider a high crime or misdemeanor. And these would encompass situations where there was a worry perhaps of a abuse of power, abuse of executive power, or a worry where there was basically a degradation of the office of the presidency. So I would make the claim that we are roughly in this territory right now with respect to the Trump inquiry. So here are some examples of what I have in mind when I think about norms that might be violated or may have been violated during this presidential administration. So for those who read the New York Times, you may have come across this op-ed. David Leonhardt, one of their op-ed columnists, had this great op-ed, I think probably a couple months ago. But the title of it was Just the Facts in 40 Sentences. So it goes on for 40 sentences, but I'm not going to read 40 sentences. I'll just read a few of them. But this is how he opens the article, the op-ed. He, referring to President Trump, has pressured a foreign leader to interfere in the 2020 American presidential election. He urged a foreign country to intervene in the 2016 presidential election. He publicly undermined American intelligence agents while standing next to a hostile foreign autocrat. He encourages foreign leaders to enrich him and his family by staying at his hotels. He described white supremacists as some very fine people. He told four women of color, all citizens and members of Congress, to go back and help fix the totally broken and crime-infested places from which they came. Now, I would argue that all these things could be considered as violations of these background, implicit constitutional norms. And what I think is particularly striking about Leonhardt's list of these moments in the Trump presidency is that one would be very hard-pressed to think about a president in our recent history where you could sort of draw analogs between this behavior and what we've seen before. It really makes this behavior sort of stand out as quite aberrant and abnormal. Now, I will say, just because you have a president who transgresses norms, I don't know that I would necessarily claim that that would be sufficient to say that they would be appropriately subject to an impeachment inquiry and removal from office. For me, at least, the transgressions would have to be so severe that, again, we would feel that there is a gross abuse of presidential power and or degradation of the office. And again, based upon the fact that I'm quoting this column, you might guess that I kind of think that we're in that territory right now. So when we think about like the current controversy, the current discussion around this moment in Ukraine and our American foreign policy, when I look at that sort of reconstructed phone call transcript between Trump and the Ukrainian president, I do read in it at least the possibility of a proposed quid pro quo, or at worst, something worse, an extortion attempt. And one could claim perhaps that a proposed quid pro quo done in the service of national objectives like combating corruption could be more broadly defensible. And I think we're starting to hear from some Republicans like that line of argument. The difficulty that that defense runs into, I think, is that one would have to make the argument that this desire to want to investigate Joe Biden specifically is tied to a national political goal. The alternative narrative, the alternative way to look at this is that these were actions undertaken by the president to further his own narrow political goals of influencing an election in which he's worried about a particular person as his main rival. And so I would make the argument that based upon those actions and other actions during this presidency, that we are sort of in this territory for making a potential case that we are looking at a set of high crimes or misdemeanors falling within the scope of the impeachment clause. So just to sort of, for the final portion is, I want to talk a little bit more about these norms, but to sort of link them to two other themes that have popped up a little bit in current public commentary around this moment. So the first is this idea of the deep state. I think many of us have heard this term before. It's gotten a lot of discussion from political commentators, Trump supporters, and Trump himself. And I understand the term at least to encompass this idea, this worry of unelected career federal governmental officials in the administrative state seeking to undermine a democratically elected president. And so on the one hand, these sorts of descriptions of the deep state might sound quite frightening and disturbing, especially for those who might be feeling a bit more skeptical about the federal government and the individuals who work within it. But let me offer an alternative perspective about what the deep state might be referring to. If one comes at it from another view, the possibility perhaps that the federal governmental bureaucracy is full of deeply committed career civil servants who do things like enforce our laws, protect American interests abroad, recall defective cars, monitor the spread of infectious diseases, ban unsafe medications, oversee the crucial parts of the welfare state like Social Security and Medicare and Medicaid. This nightmare scenario posed by the deep state threat may seem a little puzzling. And I think about this particularly in the context of the testimony happening right now. Because one way of thinking about these officials in the State Department testifying is one might see this, and I think some are articulating this, as the deep state striking back at President Trump for some perceived sense of the fact that he is an illegitimate president or something like that. But another way to think about what's going on with respect to these career diplomats coming in front of Congress and testifying is that these are individuals perhaps that have been committed to a career and socialized into certain deeply held institutional norms about the proper way the U.S. should conduct foreign policy. And maybe what we're seeing from them is a reaction to this idea that these fundamental norms have been transgressed in a way that really sort of offends their sense of professional obligation and responsibility. And I think maybe one indication of why that might be the case is that we're seeing, there's a number of these public letters that have come out during the Trump administration, but oftentimes many of these public letters are signed by appointees and career government officials that, sort of span both political parties. It's sort of a bipartisan component to these concerns raised. And so it sort of, again, highlights the aberrant nature of what we're seeing from this administration. And the last thing that I want to talk about is this idea about norms, but how these norms sort of intersect with the Republican Party specifically. The interesting thing I think about norms just more generally is that sometimes you don't really know the norms are there until they're no longer there. Then you start to feel their absence quite strongly. So you've already gleaned from my comments so far, I tend to lean to more of a democratic progressive perspective. So to underscore that point, let me offer an example of what I have in mind. I remember when George W. Bush was elected, controversial election, and I remember among my friends who were Democrats, this sense of feeling a bit of despair when he's reelected in 2004. And the concerns that have been raised about George W. Bush during his presidency was the Iraq War, of course, the handling of the aftermath after Hurricane Katrina. If you're a Democrat during the election of 2012, there were concerns raised about Mitt Romney as well. This comment that was quite infamous among Democrats, at least, talked about the entitled 47% of Americans who would always support Obama. That was recorded and got a lot of attention. But I would say that for all the critiques that Democrats or progressives might throw at George W. Bush or Mitt Romney for those remarks, it is also really clear that both of those are individuals who genuinely believed in these elements of these fundamental constitutional norms. And they do so in a way that's conspicuously absent from much of the leadership of the Republican Party today. The case of Mitt Romney is quite conspicuous, right? He's almost in a sense a virtually lone voice in the Republican Party who's sort of more emphatically calling out some of these abnormal behaviors by the current president. And George W. Bush is also an interesting example as well. During his presidency, the Republican Party still took seriously this idea of growing the party to encompass minority constituencies, talked about a compassionate conservatism. And if you were to go back and read some of George W. Bush's speeches on immigration and compare them to the current rhetoric of our president, there's quite a striking difference in tone and substance. And I don't know, I don't think I'm making that original a point, but imagine George W. Bush running for president today. It's abundantly clear he could not survive a primary in a Republican presidential election. The party's just moved too far to the right for where George W. Bush was during his time. So if you're a Democrat and you were a Democrat at that time, however annoyed or angry or upset you may have been about Romney or George W. Bush, I think you would be hard-pressed to question their fidelity to these certain fundamental constitutional norms that I think we're starting to miss a little bit more today. And so the last thing I'll say is this. The striking thing about the Republican Party more generally is that if you look at the course of its larger historical development, there's some interesting ideological components that sort of track both parties that are different. The Democratic Party historically has been a party of coalitions. And it had a long stretch of being quite racially exclusionary, but that aside, it also sort of had this component of really being the party of, like working class immigration, like that was an element of it, certainly in the 19th century. But it was always had this component of being a party of coalitions where the commonality of it was a little bit shakier. In contrast, the Republican Party, its roots often go back to the Whig Party in the 19th century. There are these themes of sort of unity, cohesion, societal cohesion. Those things have been prominent through the course of its history, and particularly in the 20th century, in the Republican Party, you saw much within its ideology this notion on principle above expediency, stability, tradition, things like that. And those things are hard to find today. And maybe as a symbol of what I have in mind to sort of make it more apparent or make it more concrete, it's an old Republican Party line, this idea of being concerned about the deficit out of a sense of financial stewardship. But look at the deficits that are being run up these days, right? Given the passage of this tax reform bill that happened in 2017. And the old bastions of establishment republicanism, the DOJ, the FBI, again, these elements of sort of social order and control, these are the things that Republicans now point to as the elements that are seeking to undermine President Trump. So it's a really interesting transition for the Republican Party where it seems like it's diverged quite a bit from where it's been through much of its history. And so the last thing I'll say is this. What's apparent, I guess, in my comments so far is I think that an impeachment inquiry is appropriate to go forward, given what we have in front of us. But there is a valid counter argument to make at this point. One could say that perhaps it's a worry about going down the road of impeachment at this moment where we already have a very divisive situation with our polity, much disagreement about values, about facts. Will an impeachment inquiry help in all that? And I can't say that I'm confident that it will. If anything, one imagines the divisiveness will just ratchet up a notch. At the same time, I would make this argument about why an inquiry could still be valuable, notwithstanding the risk of greater division. And the value, I think, is this. What's at stake with respect to the behavior in question with respect to the Ukrainian aid is the attempt by this president to influence the 2020 election. So if nothing else, even if this effort all fails in the lack of a conviction in the Senate, I think there's a valuable checking function on the president. And to a larger point, I do think the president remains the most dangerous branch of our government. And that would be true whether there's a Republican or a Democrat in the White House. All right, so I think I'll stop there.
Okay, so we have some time. Maybe I'll just start off some of the discussion. So the framers obviously didn't anticipate parties, but it's unimaginable to think of our government working without parties today. And going to Stuart's point about norms is really fundamental to thinking about how the Constitution operates, and especially in an impeachment context. What does it tell us when you have an impeachment proceeding that is brought, and most probably an impeachment vote that will occur on strict partisan lines? Isn't that a prima facie case that it's an illegitimate impeachment?
Good question. Great question. So I think when we contemplate the fact that there are great divisions here in the country and in Congress, and different members of both parties are circling the wagons, either supportive of or in opposition to Trump on this question of impeachment, we ask ourselves that question: Does the hyperpartisanship render this impeachment effort illegitimate? My answer is no, because I think that the kinds of constitutional norms that Stuart was talking about and that I reference in my talk have to be upheld regardless of the politics of the time, even if we find that we are terribly split. And here's why. That if our constitutional democracy is going to retain its integrity, if it is indeed going to continue, then the only way to do that is through governmental adherence to the constitutional terms, Congress Article 1, the President Article 2, and so forth. And if we say, well, in the Democrats' case in the House, if we say, well, it's not good politics right now to impeach Donald Trump, there may be a backlash, and you all know that there was considerable discussion about that. My view is that it's not only the right of the Democrats or Congress and the House to bring that, but it's the duty. It's my view that it's the duty of the House to hold the president accountable to the Constitution, if necessary, through the mechanism of impeachment. Because otherwise we lose the prospect of holding the president accountable as an essential quality from the framers' perspective, and I hope we would say that it still is an essential quality in our constitutional system to hold the president accountable, on the premise that nobody is above the law. The president's not above the law. As George Mason said in the Constitutional Convention, no man is above the law, and certainly not the man who is best positioned to exact the worst kind of injustice on the nation, meaning the president. So in my view, it's not illegitimate, but in fact it's a duty, a constitutional requirement of Congress, which means then that in this case we might say that because there have been, I think, gross constitutional violations, and let me just say I think there are probably 3 articles of impeachment that the House could bring. One would be abuse of power. The abuse is because President Trump was cutting a deal for himself in the July 25 phone call with President Zelensky of Ukraine. Zelensky is saying we're ready to receive the Javelin anti-tank missiles. We really need those. And of course, the whole world knew how badly the Ukrainians needed those tanks because they're at war with Russia and they're fighting for their survival. And President Trump, as we all know from the edited White House memo that was released, not a transcript, as he continues to repeatedly and erroneously represent as a memo, there is the line from Trump saying, but I need you to do us a favor though. There's the quid pro quo. It's extortion, as Stuart says. I would say it's pressuring, it's bribery, it's a shakedown. You'll get this if you give me that. That's abuse of power because he's abusing power for his own political ends. In other words, do the investigation on the Bidens, get me some dirt. And as we now know through the public testimony, if we did not know that previously, that in fact President Trump told Ambassador Sondland, I want you to put Zelensky in a box. I want him to publicly declare that they will conduct the investigation of the Bidens. So there's abuse of power, abusing the powers of the presidency, essentially using the full force and weight of the United States government to serve his own political ends, to bring political benefit to his campaign. The second would be, of course, an exercise in bribery. It's very clear that he engaged in bribery, which is an impeachable offense. And the third article would be obstruction of justice, as I said earlier, in prohibiting his aides, current and past, from coming to testify or releasing the documents. Not only is he violating the understanding among the framers, who at that time believed that the president would have the duty to provide all information to any congressional inquiry, because in fact at that point in England, the king well understood that he had the duty to provide documents requested by Parliament in the course of an impeachment inquiry. And for those who think the president somehow has a legal or constitutional foundation to withhold documents on the invocation of executive privilege or immunity, that can't possibly obtain, because if the framers had embraced that idea, it means that they would have been clothing the president with a power that not even the King of England had. And at that time in American history, the idea that the framers would have been empowering the president to a greater point than Parliament would have wrought tremendous controversy. So there are 3 articles of impeachment in my mind. So to do the duty of policing the president, I think, even in the partisan atmosphere, does not render it illegitimate. It's the case where the Democrats, in bringing, in holding the impeachment inquiry, it might be said, are doing their constitutional duty and rolling the dice politically. And I think that's what they should.
So Stuart, let me get you in on this, but let me sharpen it a little bit, because in particular, I think, the Republican argument in this is going to be, even if we admit all the facts that David just laid out, it still doesn't rise to the level of an impeachable offense. And in the end, that's a question about norms. What are our norms here? Right. So if half the Congress of one party believes that the norm should be interpreted away, that this is not an impeachable offense, isn't that a problem?
Yeah, I mean, I agree with that. I think, like any practice that involves these implicit norms, they're constantly, I think, undergoing evolution. Before we sort of talked about like the contingent nature of norms, right? Mm-hmm. They're going to be they're going to undergo change. They're going to evolve. There may yet be norms that we think exist that maybe don't exist after this process is over, and that's quite a possibility. I still don't think, at least at this moment in time, that going forward with an impeachment inquiry is illegitimate, because there would be this partisan division. Tracking on what you were just saying, David, when I think about the impeachment process, is ultimately there's this debate about whether it's a legal or political process, and without a doubt, politics influences it. But fundamentally, it's a legal process. It's indicated, if nothing else, by the fact that the Senate takes a separate oath when they begin an impeachment trial, right? There is a duty that fundamentally drives it that exists separate from the political calculation. Now, the political calculation will always be there, but no, I think there is ultimately a legal duty that's driving this process and should drive it forward.
Yes.
Where is the Federalist Society in all of this? Why don't we hear something from them?
So for those who don't know, the Federalist Society is a conservative legal organization that's found on many, almost every
top-notch attorneys in it.
Extremely top-notch. In fact, most Republican appointees to the federal courts have come out of the Federalist Society. So it's a conservative student and law professor organization, or legal professional association. So where are they?
No, go ahead.
Yeah. So as part of a larger thing, I'm kind of curious to see where the defenses are evolving from the Republican Party as this process continues. The latest thing I saw was Stephen Calabrese, who's one of the founders of the Federalist Society, just wrote an op-ed about this. And the legal academy tends to be a pretty progressive crowd, so take that as a sort of initial point. It did not get a very good reception. And basically the op-ed said something like, the impeachment is illegitimate, if I recall correctly, because it sort of violated all these norms around due process around a criminal trial. And the response is, this is not a criminal trial. Impeachment is clearly sort of vested within the discretion of the House by constitutional text. It wasn't a very strong legal argument from what I saw, but that's one defense I saw lately from the founder of the Federalist Society.
Yeah, and just to add to what Stuart said, their claims that it's an illegitimate process thus far can be knocked down one by one. When they said, for example, that the president is being denied his right to confront his accusers. In no investigation throughout this country are those accused of crimes able to participate in the closed-door proceedings where we're engaged in fact gathering, information gathering. When they say, therefore, that Sixth Amendment right is violated, they would be claiming a right that doesn't exist for any other defendant in the United States. In addition, when they argue that in fact that the Republicans were not able to participate, that's factually untrue. When they stormed the super secret room in the basement, remember that a third of the Republicans in the House were serving on the 3 committees that were questioning the witnesses. So anyway, I think that their claims can be knocked down one by one. And when they ask for transparency, they're getting the transparency now. They may not like it because we just saw day one, which wasn't a good day for President Trump, particularly because of the bombshell that Ambassador Taylor dropped when he said that, in fact, his aide overheard President Trump saying on a phone call to Ambassador Sondland, well, how's the investigation into the Bidens going? How's the investigation going? And Sondland hangs up the phone and said he cares more about the investigation than he does Ukraine. That sums up the story so far, I think.
Matt, over here.
I agree completely with what both of you said, that impeachment is the sort of ethically right thing to do. But I worry, though, about a possible result. There were some interview results published yesterday, the day before, in the New York Times, by a reporter talking to independent voters in some of the swing states, and very sobering to read what those people said. And that for them, this is all noise. Everybody does this anyway. Other presidents have done the same things. This is just people in D.C. being political. If, in fact, the impeachment is passed by the House and as we all expect, fails in the Senate, and the beached whale survives, and 40% of the country then believes that this was in fact a coup and not a legitimate process, aren't we then in worse shape in terms of the ongoing legitimacy of our system than we are now? Is that a possible outcome, and does that scare you?
It scares me. It does. And your question is excellent. So I would offer a couple of points here. One is when we fear that if the president survives this, that he's going to assert even broader powers. It's Trump unplugged, as they say. I hold that fear. I think that he represents a menace, just to be very moderate in my characterization. But I think he already does. And if the concern is that that the Dems should not bring impeachment for fear of the backlash that you describe, and which I worry about, reflected in those polls, then I want to say, at what point do we begin to try to hold the president accountable? And if we didn't try to hem him in or contain him or ultimately remove him, he would now feel even further emboldened. Remember, the July 25 call came the day after the Mueller report. And what did Trump believe? He said, wow, I'm untouchable. It reminded me of that same time when he gave a speech on a college campus, and he said, no hyperbole here, under Article 2, I can do anything I want. That is a claim that no president has ever made, even in this long history over the past 75 years and the rise of the imperial presidency of presidents claiming broader and broader powers. No president has dared to say, I have unlimited powers. So you raised the right question. What happens if, in fact, in your phrase, the beach whale survives? Then I think our system is in trouble.
Or he doesn't survive himself, but his base survives, and Steve Bannon comes up with someone else to run who is every bit as bad. This notion of disaffection with the government by 40% of the electorate is the part that frightens me more than Trump himself.
I mean, these risks are all there. We were talking about this at lunch earlier too. You know, whatever happens to Trump, whether he gets another term or doesn't, Trump is still going to be tweeting, right? No matter who's president. The dynamics that have been unleashed in 2016 are going to be with us for some time. And so I think I agree exactly where Richard came out. I think these are relative risks. And for me, what was worrisome about that call is, again, it's the day after Mueller testified where he sort of felt he was in the clear. This is a president who seems like there's just nothing checking him. And that strikes me as the greater reward right now.
And to add on to that, do we prefer a Speaker of the House who just said, I worry about the political consequences, therefore I'm going to turn a blind eye to what Trump has done, because if that happens, what's next?
But let me play devil's advocate, and I hate to keep bringing it back to partisanship. But, I mean, isn't there an argument that should be made? Look, you know, the alternative is you wait till the next election, which is only a year away, to hold him accountable. And the peril is you move ahead with a partisan impeachment, and that spells illegitimacy to to one party, right? And so you create the exact fears he's talking about in that group of Americans.
Yeah.
Right?
But a relative risk, right? Because again, what's at stake here is an attempt by the president to influence the 2020 election. The thing that would, so on the other side, if you just let it go, you worry having an actual illegitimate election, that skews the results in favor of the president. I mean, this is a commonly noted thing that's coming up in a lot of these discussions around these hearings, but what's interesting about this discussion and engagement with the Ukraine, it's not even that Trump wanted an investigation. He wanted a public statement of the investigation. It's really clear why that is, right? He wanted this to harm Biden in the upcoming election. So again, a risk, yeah, but then there's a risk on the other side as well. So.
Well, and I agree with the political calculus in the question, and that's of course what Hamilton addressed in Federalist 65, where he said all of these impeachment proceedings are going to be colored by deep partisan differences. It's unmistakable because people are going to align themselves with their party, or rather with their partisan interest. What he said in the end is he hopes that upon examination of facts that somehow people in the Senate will be able to rise above those partisan interests in the interest of the country. And we could ask a great question: were the framers naive to believe that in fact it would be possible for a future Congress to rise above those partisan concerns?
They certainly didn't see the parties we have today. So.
Yeah, right.
You spoke a lot to whether these are impeachable offenses, but did the framers actually discuss the weight of evidence? So, I mean, obviously the obstruction one is clear. I mean, he refuses to let his folks talk. So, I mean, okay. But in terms of the extortion offense, it seems to me anecdotal. And we don't have a verbatim transcript. We have a synopsis transcript, and we don't have 10 people coming forward and said, "I heard him say."
Yeah.
So without that, what do we really have?
So this sort of like the narrow legal question about the evidentiary burden is there isn't one, right? So it's sort of determined by legislators as they vote. So it's not established.
Okay.
Anyway,
Yeah. So 2 points. One, you're right. We don't have access to the verbatim transcript, although we could if President Trump's team released it.
Oh, so there is one?
There is one. It's locked away in that super secret file. Some of you who are really good at cracking and hacking, you should try to find it. It's your homework assignment for tonight. So it is. So you see, the president's team is trying to have the best of both worlds, right? Saying, in effect, you don't know, you weren't on the call, except Lieutenant Colonel Vindman was on the call, right? So we do have a statement about what he said. And your question about the extortion claim and how do we examine the evidence, that goes to what I would say is the second article of impeachment, that is the violation of his oath of office. Remember, the president, under Article 2, under the Take Care Clause, he shall take care to faithfully execute the laws, was not executing the law when he said to Zelensky, you'll get your military aid and you'll get the meeting in the White House, but not until you agree to conduct these investigations. If you're violating the law, you're not enforcing the law. That's the violation of his oath in a narrow way. Yeah.
Yes.
I've got kind of a general question, but the question is both of you gave a good example of, how the Constitution came and, the norms that kind of go along with that, and you gave examples of, some of the obstruction or some of the things that he may be doing. But my question is if the Constitution is the same yesterday as it is today, throughout time, it's happened on both sides as far as people, using executive privilege or not following the subpoenas like they're supposed to. So that would be my first question. But my second question is, when the Constitution kind of goes head on head with another rule or law, how does that, for instance, the whistleblower? So how do the two of them go together, or which one takes precedence, I guess?
Yeah.
I'll take the first one. Okay, so within the broad, I don't know if others have taken classes in like common law yet or whatever. Anyway, within the broader world of constitutional law, there are these really deep debates around method, right? And so maybe you can have heard the term originalism and sort of what that entails. And that entails trying to read the Constitution in light of like, original intentions, original public meaning. And there are other theories that are out there, maybe don't get as much attention, but they sometimes get grouped under the general heading of living constitutionalism. So I tend to be more inclined to that view. And under that view, it does sort of encompass this idea that constitutional principles and norms can evolve over time. So I'm making this argument based upon norms. It very much is sort of grounded in a living constitutionalist idea. And for me, the starting point is thinking about defining core concepts like what a transgression of executive power might be, or a degradation of the office. I think the behaviors that would constitute that would evolve over time because our standards and our notions of morality will evolve over time as well. To bring up another topic that we haven't covered yet, but I don't know that I'd be strongly committed to this. I'd want to think about it a little bit more, but if I think about the behavior of Bill Clinton, that strikes me as more problematic today than it may have if I was a voting Democrat back then, just given the way that our norms are around gender equality at this moment. So I think those norms are going to evolve, and I think they should. That evolution should inform how we think about abuses of power.
Well, I guess my main kind of thought behind that is just whether you're Republican, Democrat, doesn't matter, or independent, is just a hypocrisy between, the extreme sides.
That's the
They're
Federalist
using,
Society.
they're using, the same law on two different arguments.
Yeah.
That's the Federalist Society completely.
Right. Well, I
Because
agree
they
with
go
what,
with the things that Madison and Hamilton wrote.
Yeah.
That's the law.
I agree with what Stuart said on your point about the Federalist Society, and it dovetails with your question. The Federalist Society advocates originalism as the means to interpret the Constitution. So there's a great deal of hypocrisy there because they want to ignore what the framers had to say about this. And another element of impeachment that is so relevant here is corruption. What's more corrupt than the president trying to use all the powers of his office, the full force and weight of the United States government to coerce, extort, shake down, whatever you want to say, for private ends? That's grossly corrupt, and to your earlier question, framers had that in mind.
But I think there's other examples on the other side too that's just as bad.
Oh, no doubt about it. No doubt about that. So I would have argued, for example, that Bill Clinton should have been impeached, not for his affair with the intern, which led to his dissembling, but in fact for his usurpation of the war power. Cornell knows this, but that would mean that every president going back to Harry Truman should have been impeached for usurpation of the war power. Hard to believe that, and I say that just because the Constitution gives Congress the sole and exclusive authority to go to war. We couldn't have impeached every president, but maybe if we impeached one or two, they would have learned. And we wouldn't, and that was the point to your question.
It's hard
sir.
to say they usurp it when Congress gives it.
Well, there's that too. So, but that was one of the points I was making earlier in answer to your question. If we don't draw the line, if we don't hold them accountable, in this case, President Trump, what comes next? You would have to believe, to go back to Stuart's earlier point, that he would continue to solicit foreign intervention. As Stuart said, it was 2016, it's 2020, there'd be no stopping. And let's also remember that soliciting a thing of value from a foreign government is in fact a crime. It's a violation of the federal campaign finance law. So there's your crime if you want that.
And there are some responsible former Republican people, public officials, people like Joe Scarborough, who are saying, what this guy's doing is not Republican, it's not conservative, it's not legitimate. But none of those people are elected.
Correct.
Except maybe Romney.
Or the ones who say it are like retired shortly thereafter.
Let me try to get some other folks in here. Yeah, back here.
All right, so a few things. First, I just kind of want to make sure I understood your argument about the legitimacy of a impeachment hearing. So basically, you think it's legitimate not because necessarily he actually should be impeached. Like, even if he doesn't actually get impeached, like the main thing is kind of a symbolic thing to say. Like, hey, we have the power to impeach you. We might not actually use it here, but we want to make sure you remember that to make sure you don't think you're untouchable, right? Basically.
Well, I certainly would say that the House has a duty to impeach where it perceives impeachable offenses. And we don't know yet for sure if the House will do it. It's very likely. And then it goes to the Senate. And that's where the trial occurs. And we'll see what happens there.
So pretty much the idea, it's like, okay, maybe we're not actually going to impeach you. It's kind of like, hey, we still have this power. You aren't untouchable, right?
Don't we need in this country to know the truth about what governmental officials are doing? That was a foundational principle for the framers. Because if we don't have that kind of transparency, if we don't know what our governmental officials are doing, there's no way for we the people to hold government accountable. And the whole idea of our constitutional system rests on the idea of governmental accountability to the law, that is the Constitution and the people.
That was the first thing. The second thing, kind of going on, one of those guys said, like, this is not what the framers intended. Well, if you look about it, no matter what side of the spectrum you on, there's a lot of things that we're doing right now that they didn't intend. Like, if I remember correctly, they didn't want a standing military. So it's kind of a balance between, this isn't what the framers wanted versus, well, our Constitution has to change. So from your perspective as kind of like a legal scholar and expert, all that, where exactly do we draw the line? It's like, yeah, the framers probably wouldn't have wanted this, but this isn't the 1780s.
I don't know that I can see the point that this is so obvious something the framers would not have approved of. I mean, number one, but number two, I guess you're asking the question of like how far can you go out in terms of innovation where it seems like it's illegitimate?
Like,
is that the question?
Yeah, it's like it was founded by these guys back in the day, and things have changed.
Yeah,
at what point are we going to say, where's the point between it's like, yeah, the framers wouldn't have wanted this, but we have to change it.
This is the practice of constitutional law in a nutshell. I mean, that's basically it, right? We start with these documents, with these principles, and there's this endless tension in trying to think about how this document will apply to current circumstances never contemplated by the people who wrote the text. And you get too far out when you lose the credibility of interpreters, the legal community, the broader populace. But figuring out where that line is ex ante, that can be hard, if that's the practice of it.
So let me come back one more time to my hobby horse. So the practice of constitutional law is not just in the courts, and in particular on things like the impeachment power. The practice of constitutional law takes place in Congress.
Sure.
And what better evidence do we have that there is no consensus about the norms governing President Trump's behavior than we have basically an evenly split House on partisan lines about this issue?
I'd say if we had confidence that the outcome we are at right now is the stable outcome, I would be right with where your question's going, which is a skepticism or a worry about it. I feel we're in a moment right now where it's both sides who sort of feel that we are not at equilibrium, that there is yet room, if you're on the Democratic side, that once this narrative is packaged or articulated in a certain way, it will start to shape public opinion in a way we haven't seen yet. And I think on the Republican side, there is this hope that maybe once they sort of go through this line of defense of articulating these transgressions against the democratically elected president, it will turn off a substantial portion of those swing voters, and we will get the articulation of norms against the ones that I'm trying to argue for. I mean, so maybe that's where we are. We just don't have equilibrium yet. So,
well, I like that point, and so the question here is: will senators, let's say Republican senators, be moved by what they hear this week and next week? We don't know. One can hope that if the facts are clear, that the president has violated those textual premises and principles in Article 2, Section 4, has committed bribery, has committed high crimes and misdemeanors, that they'll be so moved. But they're not likely to be moved, I think we talked about at lunch, unless the electorate is ready to push senators to move in that direction. So how to accomplish that? One way to accomplish that, I think, is for all of us to contemplate what happens if a president, this president or any future president, is able to successfully solicit foreign intervention in American elections. Here are some implications. One, American elections cease to be elections of, by, and for the American people, but instead they become elections of, by, and for the American people, and just draw an example, the Russian people. I don't know. That's one question. The second is, what happens if a president does successfully solicit help from a foreign government, that is, wins with the aid of that government? If that foreign government helps that president, doesn't that president have a debt to that foreign country? And And what price would that president pay for that debt? What will that other country expect in return? And we would ask, is the president likely to say to the American people, oh yeah, I got help from the Russians? Certainly not. No president's going to disclose that, which means that president is vulnerable to blackmail, because at any point, that foreign government that in fact intervened to help the president can say, if you don't do what we want now, going to blow the whistle on you and tell the American people you solicited our help and here's what we did, which, speaking of legitimacy, would undermine the legitimacy of that president. So we've got a string of questions, important implications that Americans need to ask themselves. And fundamentally, do we want the cornerstone of American democracy to remain free, fair elections of, by, and for the American people, or are we happy to share our elections with other countries? So anybody here be happy to share our elections with?
Depends on which country you're talking about.
Exactly. Good point. Good point.
You're talking about swaying the American public, which would then sway the Senate. Is the circumstances today so different from the 70s? Because that's exactly what happened with the Nixon impeachment.
Yeah.
Didn't
Are
have
things
gerrymandering.
so round the bend now that can't happen, or can we hope it's a similar situation?
It was the televised hearings in the summer of '74 helped to convert Americans to the belief that in fact Nixon had committed impeachable offenses. I think at the time of his impeachment that 58% of the Americans, 58, not 95, 58, thought he should go. Could we ever attain 58%, or are we hoping for 51%?
Travis?
Yeah, there was an article in Politico today about this idea that the Senate, if it wanted, could hold a secret vote. And there's a lot of agreement they probably get 75 or 80 votes to find him guilty in the Senate. So first of all, what do you think of that proposal? Second of all, just by making something secret, we have a fundamentally different outcome.
Yeah, I mean,
Right.
it's an indication how deathly scared Republican elected officials are of the base. I mean, that's the story of basically our politics for the last few years. This issue about, I mean, I didn't listen to the Nixon impeachment, but from what I've heard, and there's a great podcast called Slover, and I think we're listening. But yeah, it was. I mean, the sort of the striking thing about that I picked up in hearing that discussion was that it wasn't this sort of gradual buildup, right? It was a cascade at the end. And so I've heard discussion where people hypothesize maybe we could see something like that in this case. The thought being that the idea of Democrats somehow getting enough Republicans to show over that you barely get to 67 seems unlikely. If anything were to ever happen for conviction, there would have to just basically be wholesale abandonment of Trump. It's hard, and it's awfully hard to see how that would occur today. Given where things look today.
We have time for one more question, probably. Let me see if I get somebody who hasn't been in already. Yeah, back there. Yeah.
To both of you guys, do you believe that the parties will ever reach a point of equilibrium, be it that Trump is impeached or he is not impeached?
What do you mean by equilibrium?
Like they'll both come to an agreement of like, okay, we've learned from him, like let's reform.
Oh.
That equilibrium.
We were talking about this at lunch. Like, what would be the next step to get us off of this cycle of just bloodletting, right? And endless conflict. And I think what were our two solutions? I mean, the one that I sort of remember.
The next generation.
Next generation.
Was my
right,
suggestion.
Yeah, that was a good one, right? Yeah. So
You guys.
Yeah.
We all have to die.
And the other possibility too, it's hard to see how this would occur, but I think what I was saying earlier was if we could think about the shape of our political universe and the fault lines of where disagreement is just fundamentally changing. And so the thought that I was thinking about when I was thinking that was, where Andrew Yang is in this debate, and his whole thing is automation, right? And it's not clear whether that's a conservative or a liberal thing. It's just sort of different. And if we ever got to our politics where the focal points of disagreement were just fundamentally different ones, that could reshape up. And so the people that we assume are our political enemies, we no longer assume that because we're all on different sides. That would be helpful. Again, I have no idea how that would occur.
Yeah, that's a great question. We all hope for that, don't we? So how to get there? One thing that could happen is that if Trump is impeached and removed, that permits a realignment. We were talking about that realignment, which means in part either a lot of Republicans leave the party and remake the Democratic Party, or Trump goes down, Democrats work with moderate to independent Republicans to form a new sense of a party. Realignment's a possibility. I don't think it's possible for that to happen if Trump survives and goes on to win re-election in 2020. Because at that point, I think his supporters within the Republican Party will say, well, Trump proved you can win this way. This is the new way to do politics. Brutality, the worst kinds of actions. And let's remember, if he does survive, he's not impeached and he wins, then everybody's going to say, Republicans alike in Congress, we don't care if our president solicits help from a foreign government. That is what remakes our system, and at that point I don't even know if we can call ourselves a constitutional democracy. Sorry to be so grim. But the hope,
on that gloomy note,
I know, but the hope is with your generation. And so our solution is, if you all can find a candidate behind whom you can rally that supports your views and drive that person to the White House with a new politics, with a new approach, a new generational leader.
So let me, before I ask you to join me in thanking our guests, let me remind you our next event is next Tuesday at noon here in the Foley Institute. We have Peter Chilson, who's going to be talking about the jihadist movement in Mali. So I think it's fascinating. We had him here 2 years ago, and it's a great presentation, so I encourage you to come to that. Now join me in thanking Stuart, Chinn, and David Adler.